have the benefit of security details paid for by the state from taxpayer funding I have had to undertake at huge expense and prejudice, funding security for my family and me. So the witness has complained that while there's protection provided to the Commission and its staff, he's had to foot the bill for his own protection. I want to clarify and place on record that I've been advised by the Commission's head of security that the Commission has previously offered the witness protection services. I understand that he declined the offer as they already had arrangements in place. The offer, however, remains. And I would go so far as to propose, Chair, that in light of the threats received, the Commission could better protect the witness in other ways, not through an in-camera application, but by renewing its offer of protection services that was made earlier, and to consider the contours of the offer of the protection services, whether it's transit protection or static or both, and to do so on the basis of a threat and risk assessment, which I think, in fact, first of all, a threat and risk assessment with the assistance of the state security or crime intelligence or both would actually be important, because a properly resourced TRA is likely to identify the source and nature of the threat more expeditiously than a report made at the local police station. So it goes to the point, Chair, that you raised at the outset about the credibility of the threat, the source of the threat, what actually lies behind it. And having a well-resourced threat and risk assessment made available to the witness will provide a more meaningful measure of protection for the witness. And I would propose that those measures be considered, and if the threat and risk assessment shows that there's a basis and for providing, whatever range of services are necessary, then that can be considered by the Commission, and if necessary, it may even be in place for the duration of the work of the Commission. And again, I say so on the advice of the head of security for the Commission. But that is a meaningful way to address what the witness has brought to this Commission, the risk that he says he faces and the threats that he's received. It's not the first time that the Commission would be offering services. It's done so for other witnesses who have come, and those witnesses have testified in open. So, in open session. So those are my submissions on the application itself. There are a few other issues I just would like to touch on very quickly. The first is the issue of the bundle that is to be provided to the witness. And I'd like to again clarify that that bundle is not there was a bundle that was provided to the witness some time ago. And what is to be provided today are additional documents that will be used for the purposes of examination of the witness on the 9th and 10th of March. So it's the original bundle plus some additional documents. So the delay is not for the provision of an entire set of documents. It is for the additional documents. The reason it couldn't be provided earlier was because the evidence leaders were awaiting the statement, which only arrived on the 4th of March, the statement that was due on the 27th of February. And the reason for that has got nothing to do with ambushing. The witness seems to be paranoid about the posture of the Commission. And there's really no basis to be concerned about that. The purpose of the statement is something that is common practice by all commissions, in fact, not just this Commission. A witness comes, a witness provides a statement. It's for the benefit of the witness. The witness gets to provide his or her version unfiltered by the evidence leaders. That was why it was important to get the statement. And of course, if the witness were to say he didn't wish not to provide a statement, in the end, well, there's nothing much that the Commission could do about that, but the cross-examination would continue in the absence then of a version in writing by the witness. So the second thing is what it does is it allows the issues to crystallize, to understand what is actually in dispute and not in dispute, what are the things we need to cover with the witness.
You are left,
only upon receiving
you are left with 5 minutes.
Thank you, Chair. I'll be done in 4. And so it was necessary to receive that so that we could crystallize the issues and know what documents needed to be added to this bundle. It will be provided today. The second is on the answering affidavit. The purpose of the answering affidavit was to put up those media reports so that the commission, so that it was properly placed before the commission, so you could have regard to it in determining this and considering the argument of the evidence leaders and where we are coming from when we say practically there is no, it would be futile to have an in-camera hearing. We needed to set that out. That was the purpose of the answering affidavit, not to respond ad seriatim to the applicant's affidavit. So to the extent that there were issues like the 2 witness issues that were not addressed, that was the only reason why it wasn't addressed. Again, we're not in adversarial mode here with the witness. We just wanted to make the evidence of the extensive media coverage available to the Commission properly. So I'm going to resist the provocation by Mr. Carrim, I won't say by my learned friend, in his affidavits and his remarks about the Commission and the Commission staff and the evidence leaders. I could say more, but maybe I'll just leave it at what Justice Fisher said in her judgment when she was determining the urgent application that was before her and about what she thought was the unreasonable conduct of the witness in paragraph 19 of her judgment. I won't say anything further on that score. I'll leave it at that, Chair. So that really is our response. I am here addressing the Commission on behalf of the evidence leaders to this in-camera application, Chair.
Thank you, Ms. Hassim. I have just